3 minutes.
I thank the gentlelady for yielding. Mr. Speaker, in April, the Supreme Court will hear oral arguments, United States versus Texas, a case that has been repeatedly litigated by our colleagues in the halls of Congress. And this resolution is absolutely about immigration policy. Let's be clear. Numerous hearings have been held in our committee challenging the constitutionality of deferred actions for parents of Americans. And our colleagues, instead of moving forward on comprehensive immigration reform and fixing our broken immigration system, have instead insisted on putting forth a resolution. The resolution that has no substantive findings, makes no legal arguments against the executive action, and exists only in the hopes of securing time before the court during oral arguments. And if our colleagues do find themselves before the court in this case, it would be helpful if they remember the settled constitutional law on this subject. DAPA is a lawful exercise of executive discretion well within the bounds of the Constitution. It's based on laws enacted by Congress that grant broad discretion to the Secretary of Homeland Security. Since 1952, Congress has authorized the executive branch to establish such regulations, issue such instructions, and perform such other acts as it deems necessary for carrying out its authority. And within that authority, it's a reasonable exercise of the discretion delegated by Congress to do what it's doing. The executive action focuses the limited resources of the Department of Homeland Security on public safety priorities, ensuring that we are deporting felons, not families. And it's important to recognize that Congress appropriates enough money to remove less than 4% of the unauthorized immigrants now in our country. The Secretary of Homeland Security has the statutory responsibility to set enforcement priorities and to adopt policies necessary for meeting these priorities. It's consistent with the actions of presidents of both parties for the last decades, including President Eisenhower, President Reagan, and President George Herbert Walker Bush. In fact, the strongest historical precedent for DAPA was the Family Fairness Program implemented by Presidents Reagan and President Bush. These executive actions will strengthen our communities, keep families together, and grow our economy. This resolution is not about limiting executive authority. It's about attempting to reverse immigration policy set by the executive branch. And I understand why my friends on the other side of the aisle don't want to admit that, or they want to frame it in the context of a constitutional question. But it's really about changing policies that are keeping families together, that are making sure that we properly allocate resources to the most serious individuals who should be deported, those who have committed crimes, and keep families together while we work to fix our broken immigration system. This is about a fundamental change in immigration policy that will rip families apart, that will undermine our values as a country. And we ought to call it what it is. I urge my colleagues to vote against the rule and vote against this resolution.